Okay, is this being recorded?
Could I ask a question if
Yes, Vinny,
nothing's
go ahead.
happening?
Yes, go ahead.
I was just reading the chapter on standing in the
Yes.
textbook, and it
Yes.
said something like certiorari, and you could, a stranger could apply for it. I mean, I know habeas corpus is the one that has the most lax requirement for standing. Any member of, anybody could apply for that. But even certiorari and now I can't remember, one of the other prerogative writs also has, they said like a stranger could apply.
I'm not sure about that because one of the major rules as far as common law is concerned is that we need to be able to show standing so that the court is not interested in trying to deal with a matter over which there's a person who's trying to litigate and he actually has no legal interest in the case. So that seems to be contrary to what we know in case law. So I would be interested in knowing how that happened, that a stranger can just have legal standing. I'd be interested in knowing what that is. Do you have it with you? All right. So as far as legal is concerned, if they have a special interest. So there you go. So there is a special interest. So it's not a stranger as in stranger. It's a stranger with a special interest. So if you remember, when we had the legal memorandum, and the question was whether or not the non-governmental organization, which was the Queensland Children's something, the question was whether or not they possibly could have, let's talk about the exams. Okay, we're going to get to that in a short while. So the question was essentially whether or not it was possible for them to file an application in behalf of Julian. And the answer was yes, when it came to a merits review, but not when it comes to judicial review, because the rules on standing are stricter in relation to judicial review. So that will still be the rule there. Okay, so let's talk about the final assessment revision. Any questions so far before we proceed? Okay, so for tonight, our goal is to be able to cover the topics that are likely to be covered in the final assessment. So you have an idea as to what areas you should be focusing on, because the timeline is that you've only got 36 hours to answer the final written assessment, and obviously you've got lives during that day, so you won't really be able to devote 36 hours to answering the final take-home paper. I'll also be discussing in this tutorial the assessment structure, and I would like to provide some tips on how to do well in an assessment. And I will explain why these tips are actually important. Because it's one thing for you to know the law. It's in fact one thing for you to be able to say, where's that? How can I turn it off? Start with the tips. Yeah, we could. Where's that? There is a point from Rachel. How can I turn it off? Okay, I'm getting distracted with that. With the chat there. Oh, the mic. Okay, hold on. Wait. I'm going to turn off the mics of everybody just to make sure that we don't have too much noise. So I've muted everyone else. If you wanted to use the mic, just turn on your mic and I'll give the floor to you. Let's begin with the assessment structure, and then I'll go to the tips. And I'll explain why the tips are actually crucial. And in doing so, I'll provide guidance as to why the assessment tasks are crucial and how they actually prepare you to become better solicitors or better lawyers. So let's just go through the assessment structure before we talk about tips for the assessment. So as you know, the final written assessment will be released on the 17th of February next week. So it's just a matter of a few days from now at 11 a.m. in the morning, AEST. There will only be 3 questions in the final assessment, and you will be required to answer all of them. Now, each of the 3 questions is worth 20 marks and carries an equal weight. So each question carries an equal weight. They're just as important as the others. The 60 marks then will then be converted to 50% of your final grade. I also wish to emphasize that all questions are in a problem format. So there won't be any questions that just ask you to explain what the state of the law is. There will be a problem format. There's a factual scenario that obviously involves a legal problem, and you're supposed to provide legal advice to a client in that factual scenario. So everything, all the three questions will involve a problem format. And crucially, the questions will be patterned after the tutorial questions. So therefore, when I explain what the topics will be covered in the final written assessment, I would strongly suggest two things. One, three things actually. Review the tutorial questions, because the final questions in the final written assessment, the questions in the final written assessment will be patterned after the tutorial questions. And you will see, therefore, a strong similarity between the questions I ask in the final written assessment and the questions I ask in the tutorials. Now, the reason for that is that I'm applying what is known as the ladder approach of teaching, in the sense that we build on your learning in the course through the tutorial exercises. We build on your learning, so it's called scaffolding actually. So we build on what you've learned in the tutorials and allow you, provide you sufficient opportunity to apply what you've learned in the tutorials as well as in other, the lecture videos and the lecture notes, and apply what you've learned in the context of the final written assessment. So what I'm saying is, the kind of questions, problem-based questions I'll be asking in the final written assessment will be very close, will be very similar to the tutorial questions. So the more familiar you are with the tutorial questions, that's an advantage. That's one. But secondly, I would like you to pay particular attention to the way that I've given answers. Okay? So the way, what happened there? What happened here? Wait a minute. Okay. So the way that I provided answers to the tutorial questions should provide you some guidance on how you logically present your answer. Now, with a crucial disclaimer, the tutorial answers that I gave, which were the model answers, are not very comprehensive because they are not meant to be. We might say that the detailed exposition of what the answer is can actually be found in our tutorial sessions. So the answers I provided in written form to the tutorial questions are shorter. So assuming, therefore, that you come across a tutorial problem that is quite similar to the tutorial questions that we've had, the assumption is you should be able to expound on your answers so that your answers are complete and obviously thorough and obviously accurate. So your answers in the final written assessment should be more comprehensive and more thorough than what you see in the model answers that I have given. Okay, so I hope that was clear. But the model answers I've given give you a sense of how to approach a problem-based question. And oftentimes, you will likely see that I follow the IRAC format, and I will explain how the IRAC format, which is the traditional approach to answering problem-based questions, is actually closely linked to the assessment criteria that we have as stated in the course profile. And then I will explain as well why the IRAC format is actually the correct and the proper approach to answering legal problems, or in terms of presenting a legal advice or legal opinion that will assist your client who has a problem. So as I've said, going back, there are three points that you should observe in relation to the tutorial questions that we've had in the past. Pay attention to the tutorial questions, because the questions in the final written assessment will be patterned after those. They'll be closely related to the tutorial questions. Secondly, examine my model answers, because that gives you some guidance on how to properly answer a legal problem. But thirdly, I would strongly encourage you to go through the lecture video, because it is rather not the lecture video, rather go through the tutorial recordings, because that is usually where I elaborate on the legal principle or on the case law that addresses a legal problem. And as well, during the tutorials, and as shown in the tutorial recordings, that is where we have a lot of discussion about the tutorial problem. So it gives you a broader sense of what alternative views are, but in the end, we then say that this is the correct answer. So that just exposes you to various legal thinking from the viewpoint of your classmates' different answers. But the tutorial recordings provide a lot of guidance in terms of having a better understanding of what the relevant legal principles are. And as I said, I will only be, in a short while, I will tell you what the 4 possible topics are. And so therefore, I would suggest you focus your attention to reading the tutorial questions related to those 4 topics, and then make sure that you actually listen to the lecture recordings in advance, meaning prior to the assessment date on Wednesday. Just go through them so you become more familiar with the legal principles involved. And it will also be better if you actually listen to the lecture video. So if you do that, and if you could read a book, maybe not, you don't really have to, I guess. But if you listen to if you read the lecture notes, listen to my lecture videos, and listen to the recordings, I would imagine you should do well, quite well. And especially if you pay attention to the model answers I've given that answer the tutorial questions that I formulated. Okay, let's proceed. If there's a question, feel free to pick up the mic or write something in the chat box. Okay, it's not visible to me though. Hold on.
Hey, Manjo.
Yes, Jacob.
Did you already mention the word count for those 3 questions that we have to do, or?
Right, I actually haven't. So thanks for pointing that out to me. Hold on.
Because is there a lot of room to move? Like 3 questions, you know, if you've 600 words per question or something, that's good. That's a lot of room to move.
Yep. The word count is going to be 800 words per question. That's the maximum word count is 800 words per question. It will be in the instructions, which I'll be giving. So there will be 3 questions only, and you will only be allowed 800 words maximum. There are 2 aspects to the word count. One is the maximum. There is also an expectation of a minimum. Okay, let's clarify the word count. You will also be required to provide a bibliography, and I'll explain why. The bibliography and the footnotes are not counted in the word count. Okay, so the maximum word limit per question is 800 words. The footnotes and the bibliography will not be counted in the word count. So it's just going to be what is in the body, which also means that avoid restating what the case facts are. It's a waste of words. Do not restate the words. I mean, the case facts. Now, let's see. So there are 2 aspects to the word count. One is the maximum. Don't go beyond the maximum. I don't want to see an extra 10% to the word count because it's the maximum. Don't go beyond the maximum. I don't want to see 801 words. There will be deductions for that. Secondly, because there is a word count, there is a minimum expectation of what the word count should be. So in other words, if the standard word count is about 800 words and then you provide an answer which comprises only 500 words, you're far below the expected word count. What it will tell me, what it will suggest to the marker, is that you haven't given sufficient thought and sufficient preparation and efforts to the final written assessment. And that will strongly count against you. So therefore, when we speak of a word count, look at it from the viewpoint of the maximum. You can't go beyond the maximum. And at the same time, the number of words you have for each question should be quite close to the word count of 800. So about 700 words would be a good number. 680 perhaps would be, the tolerable minimum word count. Okay. Now, from B, can you write all the rules in the footnotes? Okay, so that's a good point. Wait, did I jump? Hold on. Okay, I think I jumped. So I'm gonna go to by doing this, by answering the question of B, I'm going, in a sense, I am now leading to the assessment tips. So I could probably do that. Or maybe before I do that, before I answer your question B, let me just have a quick look at what the assessment topics are, just so you have an idea. There are 4 possible assessment topics, and I say 4. Actually, there will only be 3 that will be covered, but there is one there that is a red herring. there won't be an assessment there, or there might in fact be, but the final written assessment will be based on these topics: judicial review versus merits review, which is quite similar to what we had in the legal memorandum assessment. And then there will be a question that addresses the grounds for judicial review, in particular, Wensbury unreasonableness. So at least I've gotten it right now, Wensbury unreasonableness. So, or it could be on error of law. And you will recall we had a lengthy discussion on Wensbury unreasonableness, which in a sense, actually in a way, touches upon the merits of a decision. And the tutorials we had raised that question of how do we know that there is Wensbury unreasonableness? What exactly is it? There was a lengthy discussion on that in the tutorials, as well as I think in the lecture podcast. So I would strongly suggest, therefore, that you revisit that one, the lecture podcasts and the tutorial recordings, in particular in relation to Wensbury unreasonableness. Then there will be a question of freedom of information, in particular in relation to the news article that I posted in Moodle relating to former Prime Minister Kevin Rudd. There is a question on that. And there was a news story I picked up just today, which came out in New Zealand. And I'm trying to create a factual problem in relation to that. I wonder if I should post that. I probably will. So I'll post something in the Moodle page sometime today or at the most tomorrow. It involves an interesting case whereby there was an owner in New Zealand. There was an owner of a property in New Zealand which overlooked a harbor. I think it was in Wellington. And then he had a neighbor who had a low-lying property. But what the neighbor did was to erect a wall that then obstructed the view of the higher property. But there was a provision in the city bylaws whereby the legislation wasn't there, but from the facts in the news, I would assume that there was a provision in the bylaws whereby an owner of an adjacent property, which was low-lying, could actually create a structure if its purpose was something that would benefit the property owners. In this case, the owner of the adjacent property, of the low-lying property, erected a structure to be used as some kind of a playground of the kids. So he erected some kind of a castle that would allow his kids to go up. But in doing so, he actually obstructed the view of the higher lying property. But as a result, the owner of the upper property ended up losing about 80% of the value of his property, because then he couldn't see the harbor anymore. And so it came up today, and I was thinking I'll create a question on that. So just post it. I don't know what the question still will be, but I'll post it there just for you to think about. I'll come up with a question that relates to administrative law. But I'll post that news story in Moodle either today or tomorrow, because it's an interesting one. Okay, so for possible assessment topics, judicial review versus merits review. And so this revision to tutorial, I will not talk anymore about the substantive topics. We've covered that enough, so I'm not going to go through that again. From Libby Tortlow, no right to a view. Yeah, okay. Just make sure, as part of the assessment tips, your answers should focus on administrative law. Don't get into criminal law. Don't get into torts law. Don't go into contracts, whatever, or constitutional law. Because the assessment is on administrative law, make sure you identify the correct legal issue from the viewpoint only of administrative law and no other. So even if you might say that a certain act or a certain decision of the executive leads to a possible crime or a possible violation of constitutional law principles, don't get into that, but only cite them if they are relevant to administrative law. So make sure that you're quite focused in identifying the legal issue solely in relation to administrative law. So the topics: judicial review versus merits review, then the grounds for judicial review, then the question on freedom of information based on the story relating to former Prime Minister Kevin Rudd, and there will be questions on judicial remedies, definitely. So let me just see some of the questions here in the chat box. Hold on. How would that be an administrative law issue? The one that I mentioned. Actually, Audrey, I'm still thinking about it, but
Would it be because they made the regulations?
no, it wouldn't be that. That would be constitutional law. It will be in relation to how they dealt with an application. So let's say somebody applied for, because actually the owner of the adjacent property applied for a permit to be able to build that structure. And therefore there was a decision that was made by the executive. As you will notice. I still don't know what the problem is, but I'm interested. I'll develop a problem that relates to one of these. So it could be like, assuming that the executive decided to grant the application for building permit, and therefore that disadvantages the property owner of the adjacent property that occupied a higher land. What are the remedies of that person? You know what I mean? That is already an admin law problem. So I haven't really figured it out, but it seems to be interesting. So there will definitely be a question on that. Okay, well, yeah, that's right. Was natural justice afforded? So that will be part of the assessment task. Now, what else are there? Okay, I'm just going to go through some of the chat questions here. Or some of the is there a lecture for freedom of information yet? Okay, I'll come up with a lecture podcast on the freedom of information over the weekend, so I'll post it not later than Sunday. So that should give you sufficient time. I lost time because we had the school retreat from Tuesday to Thursday in Rockhampton, where all the academics from the School of Business and Law and the staff are actually there. But I'll get the lecture podcast up either by tomorrow or on Sunday at the latest. So there will be one. Now, from Rachel, should we have footnotes and bibliography, or can we include all applicable law inside of our answer instead of the footnote? Okay, so let me address that because that is really a crucial point that has been addressed by Rachel. Let's talk first about what the footnote is and how we compare that to a bibliography, in case some of you are unfamiliar with the distinction, and in case some of you may have forgotten about the distinction. What is exactly the purpose of the footnote? So the footnotes are crucial, especially in the context of the Australian Guide to Legal Citations, because the footnotes actually provide the reference to any statements you make in the body of your paper. That's the primary purpose of the footnote. So any references you have, so when you make a statement of the law, for example, whether it's based on statute or you state a legal principle, you need a citation for that. That citation appears in the footnote. Now, you cite a case, you don't put the complete citation in the body. According to AGLC, the full citation, for example, CLR and so, that has to be in the footnote. The year number, that has to be in the footnote as well. You cite the case law in the body, but the full complete citation, according to the AGLC, has to go in the footnote. So that's the primary purpose of the footnote. The purpose of the footnote, it provides the citation to a reference you made to the law, of the law. So whether it's a statute or a case law or a legal principle, whatever that might be. So that's the primary purpose of the footnotes. Now, there is a second purpose of the footnote, and I actually discussed this in the context of one of the tutorials we have, but it might be worth repeating here. The second purpose of the footnote is that it provides a lawyer, and you can see this in the way that textbooks are written, and it provides a student an opportunity to elaborate on a legal principle. You do that in the footnotes. So the body provides a story. So in a problem-based format, what actually happens is you have a client who has a legal problem. And your purpose in coming up with an answer is to be able to provide legal advice to a client. And usually you only provide one specific legal advice. You say that this is what the law is, and this is my advice to you according to the law. Now, the only time when you become less categorical, the only time you become quite ambivalent is if there might be a fact that is missing. So if there is a fact that is missing, which makes it difficult for you, therefore, to provide a categorical advice, then, in that case, your answer, your conclusion, becomes a bit tentative depending on what the facts really are, because the facts are not in the problem scenario. But assuming all the facts are there, you, as a solicitor, you're supposed to say, this is the law. This is, well, you begin by saying, this is your legal problem. This is what we're trying to find out. This is the legal issue. And if that is the legal issue, this is actually the rule. And if we apply the rule to your case facts, this is the conclusion that that we would naturally have to arrive at. So therefore, the purpose of the body of your answer in an assessment piece talks about the issue, the rules, the application of those rules that leads to a conclusion. So that is the main narrative there, because you're able to provide legal advice. You end up providing legal advice according to the law and the application of the law to the case facts. You don't want to include in the body, therefore, a very detailed elaboration of what the legal principles are. It is obviously important for you to explain, for example, what Wensbury unreasonableness is. It's probably important for you to discuss what error of law means. Okay? But you don't want to bog the reader down with a very detailed discussion of these legal principles in the body of the law. I mean, in the body of your written paper, of your assessment. Because remember, the purpose of the body of your written assessment is that it follows the IRAC format. It leads to a conclusion that constitutes your legal advice. So you don't want to have two narratives there. One narrative which enables you to provide legal advice to the client according to the law and the facts. But at the same time, you don't want to be captured in that body a way of you elaborating on what the legal principles are. That's a second narrative, and it just makes things confusing. So if you want to have a detailed exposition of what the legal principle is, especially if you want to be able to draw on facts of a case, you do that in the footnotes. So that's where you say that in this particular case, as an example, in Green versus Daniels, these are the facts. You do that in the footnotes. Avoid putting it up there in the body. The body will in the body, you will say that in the case of Green versus Daniels, this is the legal principle. And then footnotes, that's where you say these are the case facts. And you can then show a strong connection between, for example, the case facts in a particular case and the case facts as shown in the factual scenario of the problem that you have. Okay, so let me repeat. There are two important purposes of the footnotes. One is that's for the referencing according to AGLC. And secondly, it's a way for you to be able to expound on the law. So you don't want to expound on the law in the body. You state the law there, you provide, 2 or 3 if necessary, if they're crucial. You provide an explanation of the law, but it's a simplified version of what the legal principle is. A detailed discussion should be in the footnotes. Otherwise, you're putting in, too much information that kind of provides a second narrative and a second story that isn't really the focus of the entire answer. I hope that was clear. So we've discussed what the footnotes are. What exactly is a bibliography? So a bibliography begins with obviously a list. Well, a bibliography refers to any source of information that assisted you in arriving at your answer. So anything that you wrote in your assessment piece would have been informed by whatever you read. So if you had read something that assisted you in arriving at your answer, and assuming that there was a reference or a source which you did not cite but informed your answer, that is part of the bibliography. So the bibliography, in other words, comprises the references in the footnotes plus any other sources of information that you used in arriving at your answer or that informed your answer, even if they are not captured in the footnotes. Because it is possible that you came across a case that is related to the case facts but was not cited in your answer itself, but helped you in better understanding or better arguing a legal position in behalf of your client. So let me repeat, the bibliography comprises 2 things. So the bibliography mainly comprises any source of information that informed your answer or assisted you in arriving at your answer. And so therefore there are two components to that. One would be the footnotes, which obviously are the direct references you made in your answer. But secondly, it also involves sources of information which were not cited in the footnotes, but actually assisted you in arriving at any conclusion or in your answers. So that can involve, textbooks, other cases that you read, but which you did not cite because they were not directly important to the answers. Now,
Mango,
yes.
the other night we spoke about the difference in your style for the footnotes, something that's probably been a bit foreign to us all. Do you have a particular format you want that bibliography in? For example, alphabetical order, double font, or double line spacing? What's your preference for that?
I'm not exactly sure. I would imagine that the AGLC has guidelines on that, on how you prepare a bibliography. It probably does. Now, I'm not exactly, I have to tell you, I won't be very fixated really. So I'm not really anal retentive in relation to the rules there, for as long as there's been an attempt to present a bibliography, that should be fine. Now, I'm not very familiar really because I don't really we don't really use bibliography in legal manuscripts. The footnotes are enough. The only reason I'm asking for a bibliography now is that it assists me or the marker in knowing how much research you put into your work. So that's the only reason why we have a bibliography. But usually, if you speak of legal manuscripts, a bibliography is unnecessary. The footnotes are sufficient. Okay? As far as legal writing is concerned, academic journals are concerned, a bibliography is unnecessary. But for the purpose of an SSP such as ours, the bibliography is crucial for the marker because it gives us an idea as to the amount of research you did and the amount of efforts you put into in doing your assessment. So having said that, as far as the bibliography, traditionally, if I'm not mistaken, you usually divide it according to whether it's a book, it's a journal article, or a case law, or a statute. Traditionally. You have to correct me if I'm wrong, because as I said, I hardly use it. That will then be according to alphabetical order. So I think at the top would be books or textbooks. The next would be journals, and then cases, then statutes. And then statutes according to domestic legislation and then foreign legislation, according to the AGLC. But you have to correct me if I'm wrong because I hardly use it. But as I said, yes.
You are correct. And you'll find it on page 34 of the AGLC.
Okay, good.
So articles, books, reports is A, cases is B, legislation C, treaties, and then others.
Very good. So thank you, Brad. So
And can I just ask
yes,
a question in regards to the bibliography?
yes.
Will you want that at the end of each question, or can we have that at the end of the 3 questions?
That's a good point. It could be at the end of the 3 questions. Okay, so for as long as there is a genuine effort to kind of comply with the AGLC, you'll be fine. I don't expect perfection there. Same thing with the footnotes. For as long as there is a genuine effort, you'll be fine. We're not going to make deductions just because you forgot to follow, rule 1.1. It's not going to be like that. There is a genuine attempt to try to comply with the AGLC citation rules, you will be fine. Now, what else do we have here? From Jacob, all other law is verboten, as in prohibited. I'm not sure what Jacob means
No,
here.
that was an old thing. You don't need to worry about that.
Okay,
That was in relation to someone asking, going off on a tangent about tort, and you were saying steering
right.
everyone back
Okay.
to administrative matters.
Verboten as in forbidden. Okay, thank you. Now, from Vanessa, we can assume an authorized decision-making, legislative scope and purpose, natural justice law will not be covered. So, yes, unauthorized decision-making will not be covered. Legislative scope and purpose will not be covered. Natural justice and law will not be covered. Fact and evidence, that will be covered, because that goes to error of law. So fact and evidence is likely going to be covered as part of the discussion on error of law. And so obviously we have a coverage of Wensbury and reasonableness. Now, do you have a right to a view? Oh, hold on. Okay, that's something else. So that was to the facts I mentioned. Wait. That's an interesting point. You have a right to a view. Good point. Good point. So assuming that I did indicate that, you make certain factual assumptions again as to what the law might be. So assuming that there is a piece of information, like we don't really know if there's in fact a right to a view, and obviously we haven't discussed that because there is actually a right to a view, it would seem, in New Zealand legislation. I'm not too sure in the context of Australian law. But either I'll make the assumption in the factual scenario, or you provide the assumption there. Okay, let's skip that.
Hey, Manjo.
Yes,
Can you hear me?
I could. Libby, yes.
Hi. I'm a little bit concerned about this question that you just mentioned,
Yes.
given that it seems to be based on New Zealand legislation.
Oh, no. Hold on.
Okay.
I'm not going to, I will not be using it in the context of New Zealand, really. The factual scenario will be in the context of Australia. So we will be applying Australian law. I'm just saying that I like the problem that, what happened in Australia, in New Zealand, but the assumption will be that if I were to have a question on that in the final assessment, it will be in the context of Australia. It won't be New Zealand.
So, Manjo, if it's a question about a neighbour building a structure that obstructed someone's view, and we haven't actually covered that in our admin learning, I don't quite know where to go.
Oh, as I said, the focus isn't going to be the rights. It's of whether or not there's a right of view or not. That won't be the focus of the question. The focus will be on the actions of the decision maker. So, as pointed out by Brad, it would be admin law as to how the decision was made by council. That will be the focus of the admin law problem. So, assuming that the owner of that property feels aggrieved because he assumes that he has a right to an unobstructed view, what, for example, are his or her remedies? So that will be the type of question we will have. Okay, and we will not be relying on a council legislation, or we won't be relying on a state legislation. We will make the assumption that there is a Commonwealth legislation on a specific subject. So I will make sure, therefore, that when I have a problem scenario, it will be according to Australian law. I'm just saying that I like the problem that I came up with, and then I will formulate a problem that would be kind of similar to that. So in other words, actually, when you come up with an assessment piece, we always have to try to formulate a scenario. And obviously, the scenario typically is quite abstract, it's hypothetical, but it will be interesting to develop a problem based on something that actually happened, and then come up with a legal problem that is related to the factual scenario. So I will make sure, therefore, that it will be according to Australian legislation. Hold on. Give me a second. Baba, Kisari. I'll see you on. I know. Okay. Yeah, Kevin's going to see you on later. Huh? Okay. See you, Baba. Okay. Yep. Well, it's hand overnight for me. I'm handing over my daughter to my ex-wife. Okay, where are we now? That's right, from Peter, one of the four is a red herring. So one of the four is a red herring. I'll be focusing. I couldn't just tell you really what the topics are, what the three topics are. So I have to put a red herring there. Can I ask, okay, from Brad, can I ask a question on the Kevin Rudd news article? Yes, Brad, I'll see if I could answer it.
Okay, hang on. I worked through the article today.
Yeah.
And I don't expect you to answer it, but maybe if you could say, are we potentially on the right pathway to answer that style of question?
Okay.
Is it okay? I'll ask the question. I'll tell you what I put,
Mm.
and you tell me whether you can answer it.
Yep.
Hang on a sec. Privacy, Kevin Rudd. So we went privacy. Read Kevin Rudd. Is Kevin Rudd's personal medical information available? I said no, it's not. Personal information is protected under FOI.
Wait.
Contrary.
I already saw a problem there in identifying the legal issue. Why did you use the word available? Did you use the word available?
Available, yeah.
No, that's not the way freedom of information is worded. Is there a
Well,
right to public access?
Right to public access.
That is the question.
Okay, so I separated in two parts.
Yeah.
Saying essentially, is his medical information, is it available for people to, to seek information on those records? And then reading the article, it says DFAT is relying upon the Privacy Act. So I looked at, is DFAT's information available under the Freedom of Information? So can you apply to receive this information? Essentially saying, yes, it is of a public benefit because the base of the Freedom of Information is transparency, and admin law is accountability of executive and its delegated authorities.
Brian, I can't answer the question without telling what the answer is. I could. But
okay, what I was trying to do was separate that article into two parts to say, well, is his private information available? Can you apply to seek information on his private information?
There was a problem in the way that I would say that there was a problem in the way that you had formulated it was a good attempt. So thank you for that. That was really good. But offhand, I would say that there was a problem in the way that you formulated the legal issue, for two reasons. One, you had stated that it pertained to medical information. So the way you couched it made the assumption that it was all about medical information, and there was little reference to the fact that in fact might be public information. Now, the second point you made, what was the second one? Was it about the Privacy Act or something?
Well, in regards to seeking information under the Freedom of Information pertaining to the records of the Department of Foreign Affairs and Trade as to the reimbursement of allowances by one of its authorities.
Mm.
So because he doesn't say, he says in the article he paid for it, but it doesn't say, did he seek reimbursement from DFAT for expenditure of his personal allowances? And then that's the information I believe would be available.
Okay, I don't want to get. I wouldn't want to get bogged down on that because I will likely be asking a question on that. So I don't want to get drawn into a discussion because I might end up revealing the answer.
Manju, can I ask a quick question about
Yes.
that?
Yes.
When I read the newspaper article,
Yes.
it made reference to the reasoning of DFAT for not releasing the information based on their requirements under the Privacy Act.
Hang on. Let me just say that when I ask the final question, it will not mean that the question is actually limited to what is in the news article. I will be twisting some of the facts to lead to a problem scenario. So it will not be 100% based on that news article. I will be adding some facts. I'll be subtracting some facts so that we end up with a problem that is less easy to answer. So I'm just going to draw on the news article in formulating the legal problem. In the same manner that when I mentioned about that scenario of neighbors quarreling, I was going to be drawing only on those facts to then develop a legal problem. But the legal problem I'm making will not be 100% according to those facts.
Hey, Manjo.
Yes.
Where did you read that article, the New Zealand story about the property?
I will post it in Moodle.
Okay.
within the day. So
All right,
from
thanks.
from Peter, manager has something he wants to assess, so he has to find some factual scenario that allows it. So issues present in the news article are not necessarily relevant. So that's right. So the way that the news article kind of framed the story will not be the same way that I would frame a legal problem. I'm just saying that the news story is the context in which I develop a legal problem. But the slant of the story is not something that I will necessarily follow. Okay, now let's proceed. So we have the public possible assessment topic. So I'd like to proceed now to a discussion of assessment tips. Okay. Let me just begin by talking about the assessment criteria, which is in Moodle. And I will draw a connection. If you'll notice, I drew a connection between the IRAC format as well as the assessment criteria. So you will be assessed according to the assessment criteria as found in the course profile, according to your correct and thorough identification and description of the legal issues. That's 20% of the marks. And then the correct and thorough identification and description of the rules and legal principles, that is also 20%. And then you have the analysis and application of the rules to the case facts, following the IRAC format. So that's about the correct and thorough analysis of the issues with exceptional critical insight as applied to the facts. That constitutes or comprises 40%. And the conclusion, which is well thought out, that comprises 10%. And then you have the observance of the proper structure and format. So proper structure and format would involve things such as sentence structure, grammatical errors or typographical errors, the use of correct font sizes. So I don't want to see anyone using a 10, which is 10 points as a font size. That's too small, difficult to read. It should be about 12 points. You have to make sure that you observe proper margins. So that's part of the structure and format. Part of the structure and format also relates to the observance of the AGLC guidelines on proper citation of legal sources. So therefore, you will notice that the assessment criteria, in a sense, follows the IRAC format. And I'll explain why the IRAC format is actually a very important way of approaching a legal problem. So we will proceed to some assessment tips. So,
Joe, sorry.
Yes,
sorry,
Catherine. Yes.
Yeah, can I just ask a question on the IRAC format, please?
Yep, go ahead.
In the rules section, it's simply a case of citing the legal rules. You don't apply the facts at that point. You just literally cite the legal rules.
Yes, that's right.
And then when you get to the application of this, that's where you apply the facts.
Yes, but having said that, you only obviously when it comes to the citation of the rules and legal principles, you're citing them with a view that you will draw on those rules and apply them to the case facts later on. So in other words, you don't state the legal principles without thinking about the case facts. So you're citing they should just be relevant. So you're only citing the relevant legal principles. So when you say relevant to answering the problem scenario or relevant to the case facts, nothing more.
Thank you.
Now, obviously the final assessment is going to be released on Wednesday, so you should start preparing and reviewing for it early. And I would strongly suggest, as I said, focusing on the assessment topics that I mentioned, and one of them is a red herring, as pointed out I think by Peter. So actually, you're going to be assessed only on 3 of those. You wouldn't know which they are. And I would strongly suggest, therefore, that you read my lecture notes, watch the lecture video, and make sure to go through the tutorial recordings. If you do that, you will be okay. The textbooks, you could, if you want to read it. But I would imagine that the lecture notes, the lecture podcasts, and the tutorials will help you a lot in doing well in the final assessment. Now, more importantly as well, you should cite cases if you could, because they provide authority to your answer. So what I'm saying is, the law is different as far as answers to laws, assessments is concerned. They're different because if you examine, for example, arts assessments or assessments for marketing or business, it's permissible for somebody to just argue his or her point. Law is more precise because you don't really have the freedom to express your own legal opinion. We don't care about that. You either cite statutes or you cite the case law. And so therefore, we're not really interested in you saying what the legal principle is without you telling us that you're stating a legal principle, because that is what the law says, either the statute says, or what the judicial decisions say. And so therefore, every time you state what the rule is, you have to make sure that you have the proper referencing, which is then captured in the footnote. Without the proper referencing, and this is what gives me a headache, and which I really find frustrating when I mark, for example, the legal memorandum, or when I mark assessment pieces. When I see answers where there is a dearth or scarcity of citations, I find that extremely frustrating. And it gives me a signal that the student is just, mouthing off information without really knowing what the law is, and without really putting in a genuine effort in the assessment. And I would like to provide a fair warning that while I may have been a bit liberal in the legal memorandum, if I see it happening again in the final assessment where students just ex cathedra kind of state the legal principles are without providing the proper citation, I will not be impressed. And chances are that student will get a failing mark for a specific answer. I need authorities to be cited. Without the authorities, there are two things that are happening. It's either one, you're plagiarizing an idea, you're making it appear as if your statement of the legal principle is your own idea, which is quite unlikely, because somebody must have said something about that, and most likely that will be a judicial decision. So therefore, you owe it to the author of that idea, that you attribute that idea to him or her. So that will be intellectual dishonesty if you don't have the proper citation. But the second point is, if you don't have a proper citation, you're making a claim that your idea is correct. But why would I be impressed by your own opinion or your own idea? You're not a source of law. The source of law would either be case law or a statute. So I'm not going to be impressed. And certainly, you can't say that according to the lecture notes of Dr. Oison, that is not a source of law either. So I would certainly be unimpressed, and you can be sure if a student comes up with answers and there's a scarcity of case law, that will be a failing paper. And I wouldn't mind failing students, really, if I see that. So that's just a fair warning. I would be very frustrated, and I will give instructions to Chris Templeton, who will be my co-marker, that if there is a dearth or scarcity again of case law or citations, that student will fail. So that is a fair warning. And there is simply no excuse, because if you look at the lecture notes, if you look at the model answers, if you listen to the tutorial recordings, I've always been citing case law or the proper statute. So it is inexcusable if somebody just comes up with an answer as if this were a political science assessment. Okay. Now, hold on. Let's just see what's going on in the chat here. There's a lot of chat going on. I'm going to address the IRAC and CIRAC format in a short while. I'll get back to that in a short while. I'll address the CIRAC and IRAC in the format in a short while. So are we clear about that? Now, concerning formatting, again, I would strongly discourage a verbatim quotation of cases, because one, it eats up into the word count. Two, it provides little opportunity for you to show your intellectual contribution. So in other words, if all you do is copy and paste part of a judicial decision, what exactly is your intellectual contribution? What have you told us? You have contributed nothing, and there is therefore nothing for me to assess you on. So what it means is, it may be permissible for you to quote verbatim, maybe 2 sentences at the most, because they really may be very important ways of restating the law or stating the law. But beyond that, I don't want to see a verbatim quotation of cases or statements in judicial decisions, or even of statute. And certainly, I don't want to see what are known as gap fillers. I've had cases in the legal memorandum assessment, for example, where a student just cited provision after provision of the either the Administrative Appeals Tribunal Act or the ADGR Act. I don't want to see that. It's a gap filler, and it sends a clear signal that the student is just trying to, worm his way or her way to getting a pass. But that won't happen. That will be a clear fail to me. So you only cite what is relevant, and I don't want to see verbatim quotation. It's a very poor way of presenting an answer. Now, the moment you end up paraphrasing a statement of a law, then you have an intellectual contribution. But more importantly, the effect of paraphrasing or restating a legal principle, for example, based on a judicial decision, is that you're stating a principle that is likely to be supportive of your conclusion. You are restating the principle in such a way that it favors your legal position. That is the effect. So when you end up rephrasing or paraphrasing a judicial decision, chances are when you paraphrase it, you're actually kind of paraphrasing it in such a way that it supports your legal position. Now, I want to be clear that I'm saying it here that answering assessment tasks involves legal argumentation. I want to emphasize that having a good legal assessment, at least from my point of view, and I could be wrong, but at least I'm telling you because that I'm doing the miking. An assessment piece, firstly, if it's a problem-based question, involves trying to answer a factual legal problem. So you're trying to provide a legal advice to a client who has a problem. But in order to do that, what we need to remember is that what makes law distinctive is that there is an art of legal argumentation. A lawyer is there because the lawyer not only knows the law, but the lawyer advocates for a particular legal position. That is why, at least at the very, very minimum, there are always two sides to a coin. There are always two sides to a dispute. There's either the applicant or the plaintiff, or you've got the defendant or the respondent. Two sides. Now, the reason why if there were no two sides to a legal dispute, then there isn't even any need for litigation. Now, the fact alone that a case law seems to be settled doesn't mean that one party will necessarily lose a case. In the end, it's all about how a lawyer or a solicitor advocates a legal position or arrives at or argues for a correct legal conclusion on the basis of the way that lawyer uses legal principles and applies them to the factual scenario so that it supports the legal position of his or her client. So therefore, answering problem-based questions involves an art of legal argumentation and advocacy and persuasion. So in other words, the way you present your answers, you're actually trying to persuade the marker, you're trying to persuade the judge or the jury that you have the correct and proper and preferable conclusion. Was there a question that I heard there?
Manjo.
Yes.
In doing that,
yes.
Should I argue the other side?
No.
As well?
No.
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 Not for the other side, but present the alternative viewpoint that the defence or the plaintiff might bring, and then say why that may not apply in this situation or whatever.
You could, but remember, you're dealing with a limited word count. So imagine, so it's like, if you are the lawyer, I mean, there will be times when a judge would ask you to kind of, provide a legal memorandum that addresses two aspects of a legal principle. But at the end of the day, you're more concerned with advocating a singular legal position. You're trying to say that this is the correct legal position. If that is so, why should you weaken your legal position by arguing for something against it?
No, you're right. But I kept thinking it would demonstrate to you that I'm applying the law to the facts, and I'm thinking of it. I'm thinking it from every angle. But you're right. You're correct. Yeah.
You're actually correct, Jacob, in doing that, but you probably do that in the footnotes. So in the sense that you're saying, this is what the case said. But even if this is what the case said, this is the way that we should apply that specific case to the facts, because on my facts, the facts based on the problem scenario is actually different. So in a sense, you're still, even if a certain judicial decision, its facts don't really support the legal position you're making, in the footnotes, you're probably making an argument that notwithstanding the difference in the factual scenario, you should be able to apply the legal principles because that is the correct way. You know what I mean? So there's still the hypocrisy there.
And one more thing,
yes,
with the preference, and it is better to paraphrase because you learn it better.
Yes. Yes.
You want to say the ratio from a case, that one line of law. Would you prefer that in the body of the advice on the page, not in the footnotes? And is it you don't want, direct quotes is still not preferable even in the footnotes? Is that
no? It really all depends. How do you intend to use the quotation? If the quotation are really supportive of your legal position and they're crucial to the conclusion you're making, obviously you don't want to put it in the footnotes. You want to put it up there in the body. But having said that, you don't want to cite you don't want to quote 3 sentences. That will be too much. I would like to see paraphrasing. But chances are it would be a good idea to probably fully quote 1 or 2 sentences if they are really well written.
And one more thing.
Yes.
You were talking before, and I won't ask anything else after this. You're talking before about how some students do like a statutory provision dump, and they put all the different provisions into it.
I hate that.
But if you're doing a similar thing with cases, is it better just to get a couple of key cases that support your argument and do all that than put in just all these? I might have 2 key cases there, or 3, but then I think, I want more. That'll get me more marks.
Yes.
That's my reasoning, right? So I start chucking all these things.
Yes.
Is that so good?
Yep. So that's a very good approach, Jacob. You could cite 2 or 3 cases that support your legal position in the body. And then if you want to add more and you want to be able to impress the marker that you know a lot, you want to be able to put that in the footnotes. Don't overwhelm. You don't have to flood your answer with so many cases, because at some point, some of them may be contradictory or some of them may be less applicable because of differences in facts. So you just focus on the cases which really support your legal position. Now, if you want to add more, do that in the footnotes. Now, more importantly, when in talking about, when you cite a case, for example, you don't want to discuss a lot of the facts in the body. You want to do that in the footnotes. Because the moment you start discussing the facts of a case, then you're making a second narrative. That's another narrative, another story you're making. And remember, the body is really just a story about the legal advice you're giving to your client. So therefore, another story that tries to explain what the legal principle is, another story that tells us what the case is all about, that's a distracting story, a distracting narrative, a digression from your attempt to provide a coherent answer to your client. So in that case, what you do, put it in the footnotes. So now, again, a reminder, really avoid a mere repetition of the law. So if all you do is to dump, principle after principle, case after case in the body, that doesn't count for much. Because as we said, this is an open books assessment. And more than that, if you just dump principle after principle, at the end of the day, my question is, what is this all about? If what you did was to throw, case law after case law, legal principle after legal principle to your client, what will that do to your client? The client is going to get confused. So what you want to do is to be sparing so that you only state case law or legal principles that really lead to the conclusion that you're making. Okay, so avoid just dumping principle after principle. We want to be able to see the connection of the relevance of those legal principles to the problem scenario. And so at least this is part of the format. Make sure that this is formatting, which is 10%. Use connected prose and coherent sentences. So what I've often noticed is that some students are actually unaware that they've committed problems with grammar. And sometimes, especially for you guys, because you are native English speakers, and obviously I'm not, you'd be surprised why I end up, saying, oops, that's ungrammatical. But that's just the way it is. I'm kind of more aware about the rules of grammar. And it can, oftentimes it might be a problem for native English speakers because some would tend, and I'm not seeing it often in the law school though, but some would tend to write in the way that they speak. So the way that they would speak, they kind of copy that in their writing. But we can avoid, we can typically speak in grammatical ways. That won't be too obvious. But when you put your thoughts in writing, the grammatical errors are just really evident. And so, missing or the, those types of things are pretty obvious. Okay. Now, again, one way to approach writing your assessment paper is to think that at the end of the day, what you're trying to do is to provide advice to your client. So because you're providing advice to your client, you only want to be able to cite case law that is relevant to the client. And more importantly, what you want to do is to be able to draw the client's attention to what the law is and how the law applies to his or her case. So that is where the analysis comes in. That is where the application comes in. Without the application, without the analysis, you have failed in your job as a lawyer, because you're not there to lecture your client as to what the law is. Your client comes to you because he or she has a legal problem, and the client wants you to inform him what the state of the law is and what he or she should do. So you should always be conscious of your goal, which is to provide legal advice to your client. Now, it also means that the other thing is, assuming that in a problem scenario, there are case facts that seem to be missing, chances are those case facts are missing on purpose, they are deliberate. So for example, it might not be clear whether or not the AAT Act applies because it hasn't been said. Or there might be certain facts which are missing and which should have been crucial in arriving at a definitive conclusion, which is why I said earlier, you should arrive at a clear-cut conclusion. This is the legal advice you're giving to your client. You don't say, you can do this or you can do that. You're saying, this is my advice to you based on the law and based on the facts. Now, the only time you become tentative in your conclusion is when there might be certain facts that are missing. And therefore, you're saying that unless I know what the facts are, I can only tell you this much. Now, it also means that if you're going to make an assumption, it's also crucial that you state that you are making an assumption. For example, if you're making an assumption that the AAT law may apply or the AAT Act may apply, then you might say that assuming that the AAT Act applies because under that legislation, it provides for a review by the Administrative Appeals Tribunal. So you will notice that the way that it was stated, it was clear you were making an assumption, and it was expressly stated there that you were in fact making an assumption. But if all you do, if what you then say is, the law says that the review by the AAT is available, but yet the facts don't say that, then you would have been mistaken. So if you are making an assumption, you have to be very explicit that you are making an assumption. Okay, now let's talk about the IRAC format. So it'll be helpful to follow the IRAC format. One, because it's the most logical way to arrive at a conclusion, but secondly, because that's actually the way you're being assessed. Now, you will notice that the IRAC format actually follows, as I mentioned earlier, the assessment criteria. So issue, rule, analysis, application, and conclusion. So your goal, as I said, at the end of the day, is to provide legal advice. So when you say that you're providing legal advice, what you're actually doing is to give a conclusion to your client. You want to be able to arrive at a conclusion for your client. So arrive at a legal position. You need to arrive at a conclusion. But before you arrive at a conclusion, the correctness of your conclusion depends on the correctness of the identification of the legal problem. If you incorrectly identify the legal issue, you can be sure that the conclusion can only be wrong. Okay? So the critical task of a lawyer is being able to know what exactly is the legal issue, what exactly is the legal problem. Because if you have a set of facts, you can actually attack those set of facts from different angles of law. It might involve tort law, it might involve civil law, it might involve constitutional law, even it might involve criminal law. The focus of the assessment, remember, is administrative law. Now, having said that, you should also make sure that you're able to correctly identify the correct legal issue. So even if there might be administrative law issues involved, but if they are peripheral, don't discuss them. Focus on the key legal issue. What exactly is, so you have to be able to identify that. And then if you know what the legal issue is, you only cite the rules or legal principles that help you in addressing the legal issue. So don't dump legal principles after legal principles that are irrelevant to the legal issue or irrelevant to the case facts. Now, so what it actually means is that when you start writing your assessment piece, and this goes back to the question of whether or not it's the IRAC or the CIRAC format. The CIRAC format isn't really far apart from the idea of the IRAC format. What the CIRAC format really says is that at the start of your answer, you're already stating your conclusion. Okay, and then the rest follows, meaning you follow the IRAC format. I think that is the correct approach. You state your conclusion at the start. Under the facts, this is the legal advice I would give. And then that's when you state that you provide an answer according to the IRAC format. So a short conclusion that comprises or that constitutes the legal advice you're making to your client should always be there at the start of your answer. That's a good one because it already gives a signal to the marker or to the reader or to the judge what it is that you're arguing in your answer. So if you don't do that, if you don't begin with a short conclusion, you leave it to the reader to figure out what it is that you're saying. But if you state your conclusion, it naturally follows that anything that you state, that you write after that, is probably in support of the conclusion that you have arrived at initially. Okay, so the CIRAC format is good form, it's a good approach. Begin with a short conclusion. And then that's the next step of, obviously, is that if you need to be able to articulate clearly what the legal issue is. Okay, and then, as I said, the rules, say the rules that are relevant to the case facts and relevant to addressing the legal issue. You need to make sure as well that you're applying the rules to the case facts, and then you arrive at the conclusion. So I guess that's it. What time is it now? It's almost 9:20. Okay, I guess that's it. Do you have any questions? Now remember, as I said, just as a reminder, at the end of the day, it's all a matter of legal argumentation and advocacy. So you have to make sure that you're using case law, you're using the statute, you're using legal principles in a way that support the legal position that you're advocating. So you're using legal principles to support your conclusion. So you don't use legal principles because they are there. You're citing them because you know they will support your conclusion. Do you get it? That's part of legal argumentation. Okay, questions? Is there anything else in the chats which I've missed?
Man, sorry, have you
Yes.
not written the assessment yet?
No, I haven't. I've started. I've actually started, but no. That's the beauty of the final online assessment, because we can write it towards the end, and which gives me some kind of a flexibility in looking at what's in the news as well, or I can assess what seems to be interesting to students. But more important, as I said, look at the tutorial problems, because I'll come up with a subset of problems that kind of are similar to the tutorial problems that we've had. Now, is there only one issue per question? That's a difficult one, because I don't know how to answer that, because as we said, before you give legal advice, you're meant to be looking at the grounds for review. You're looking at what court you're considering. You're looking at judicial remedies. So that's difficult for me to answer. Okay, there is a private question. I wonder if I should answer that. Is there a preferred method of application? I'm not sure how to answer that. So as far as the application is concerned, this is the rule. And then you're simply saying that if this is the rule, these are the facts. Therefore, if you apply the rule to the facts, then this is the conclusion. That's simply the way it is. So I'm not sure how to do that now. So the recording will be uploaded, should be uploaded tonight. The recording of tonight's tutorial should be uploaded tonight.
I have a question.
Yes, Rachel.
Hi.
Hi.
My question is that when you mentioned that for the cases that support our essay or answers, we can put the facts in the footnote. Sometimes that makes it very long. So do we need to put the facts in the footnote, or if we can get away with just putting the ratio or the sentence that we need from the case in the body of the assessment, is that good enough?
That's right. There is no requirement at all for you to discuss the facts in the footnotes. There is no need. You only cite cases because you have to cite the reference to the statement of a legal principle. That's why you say this is the case. So there is no reason why you need to have to discuss the facts of a case. But sometimes you want to be able sometimes you want to be able to cite the facts of a case, especially if those facts are quite similar to the factual scenario. Because then in that case, that's the case facts really support the legal position you're advocating. But otherwise, it is sufficient that you just cite the case law in the footnotes and nothing more.
Okay. And if we can get away with just mentioning, if the facts on that case was similar to our situation, if we can just mention that for example, that case, this was decided this because of this, and we can just put it in the body of an answer in one or two sentences, is that going to be okay?
No, that is something else. If you're saying that the case facts support your answer, you don't have a choice. Yes. You have to indicate why the case facts support your answer. That's something else.
So we can put it in the body.
You could, but if it's really extensive, put it in the footnotes. My point is, there is no requirement that you have to explain what the case facts are every time you cite a case. There is certainly no requirement for that. Okay, we begin with that. Because all you need to do is, if you cite a legal principle, you want to be able to provide the proper referencing, so you probably cite a case. There is no requirement that you have got to be able to state what the facts of the case are. That is unnecessary. But if you say that this particular case is similar to the factual scenario, now you have put yourself in a position why you have to explain why the case facts are similar to the factual scenario, because that's what you said.
Okay.
Okay.
Perfect. Thank you. One more question.
Yes.
When the final marks will be available?
I can't remember it's somewhere there in Moodle. I should have posted it. I can't remember now. Good night, Audrey.
I will look.
Good night. So I think.
Thank you.
Well, it's past the bedtime for some people. 10:30, I think, in the case of Audrey. So maybe this is about the time to wrap things up. Certification of grades. The grades will come out on certification day. I don't know when that will be. So I wish to thank everyone again for being a very engaging set of students. Thanks a lot. I'm glad that we had a very high participation rate. Oh, my dog's name is Rocco. So did you see the dog? So I'm very glad that we had a very high participation rate at our tutorials, which made it really engaging. And I must say that I had a tough time having these tutorials because a lot of the students are just really, really good. In a sense, there was kind of intimidating for me having to confront so many very good students. But I enjoy the exchanges that we had. So thank you everyone for being fantastic students. I learned a lot from you as well. And I'm hoping that you do find the time to provide an evaluation of a course, because that's crucial for me and is mandatory in the school. So please find the time when you could to provide an evaluation of a course. So thank you, and I wish you all the best in our final assessment. And good night, everyone. Bye.